Sometimes like all you want to do is run. Hear me out, hear me out. It's all the things you never show. There are the things I want to know. Secrets start in your heart so slow. But if you don't want to tell me now, I guess I'll never know. Losing almost all my energy.
Hello, Alicia. Welcome back to another little live Q&A. How you doing this morning?
Oh man, I have had a day. I have had a day, Mark. You know that first snowfall of the year when the roads are just complete garbage and there's like about that much ice coating absolutely everything and people are sliding all over the place and the buses aren't showing up and they're not telling you the buses aren't showing up and then there's kids waiting outside for 40 minutes in minus 20. That's the day today. So
Yes,
yeah.
indeed. Yes. I just recorded episode 124 of the podcast this morning. Alicia was going to join me, but she had to go rescue her daughter. So episode 124 is me going solo, which I haven't done for quite a while. And it's definitely not quite as dynamic as when Alicia joins, but we mixed it up and the show must go on, as it will. So we are very grateful. And we just want to give a shout out to Journey Business Plans, which is the sponsor of our podcast. And they've been a real strong supporter of what we've been doing here at the Canadian Immigration Institute and for Holthe Immigration Law. So we appreciate their support. And if you haven't had a chance to go check them out, please do at journey, joorney.ca. All right. So let's see who's tuning in to join us here at this lovely October 25th morning. And we have G2D2. It's always nice to see you as well. We've got Wagner. Hello, Wagner. Abrazos to you too. He says, good to see you both. Cold has arrived in Alberta. Yes, it has, Wagner. Yes, it has. Definitely, definitely. If you are new to this live Q&A, this is where Alicia and I jump on every Wednesday at 10 a.m. to answer your questions about immigration. If you have a question like, Mark, how do I immigrate to Canada? Alicia, should I leave Canada? And will my work visa still allow me to come in? Those are questions that you really need to book a consult with. And so what will happen is you will hear a little triangle just like that. And that is the indication that the question you've asked is really too specific for us to be able to properly answer here within the context of this live Q&A. And so we recommend that you book a consult so we can go through everything and make sure we're actually giving you proper legal advice. So keep that in mind. If you're wondering why I'm not answering your question, I see some people just keep reposting it, and that's why, you guys. So we generally try to get through as many questions as we possibly can, and the more general in nature that would benefit the most people that are watching, those are the ones that I target and key in on. So I'm kind of the gatekeeper, and no, we won't answer every question that's posted, but the ones that we feel will be the most benefit to the viewers, we will pull those on. So there we have it. All right, Alicia, what do you think of this current world of immigration and the recent changes? We've had a few things that have unfolded recently. We did have a round of invitation that happened yesterday. And what are your thoughts on yet another provincial nominee draw?
Yeah, well, I mean, the good news is they're still doing draws. The bad news is if you don't qualify for a PNP, then you're pretty much out of luck. If you didn't get already a nomination from one of the provinces, because that nomination, keep in mind that, this is a huge score, 776, and people are going to say, well, how can I possibly have a CRS as 776? It's because if you do have a provincial nomination, that nomination gives you 600 points. So really, those people had about 176 points. So that's a realistic CRS score. It's not hard to get 176 points, but those provincial nominations are key. So those are the only people who are invited into this round in this PNP specific draw. We will have to see if they do another category-based draw or another no program specified draw. Mark, you and I have been pushing and hoping for a CEC only draw, because that would be the right thing to do to try to really give a leg up to all those people who've been in Canada. There's not been a CEC only draw since I think it was September 2001, so it's been 2
Yeah.
years, I think.
Yeah. A long time, a very long time. And if we go through and we look, yeah, September the 14th, 2021 was the last CEC. And I still don't understand. I'll be honest, Alicia, I'm not understanding the rationale for doing what they're doing. I'm just not. So maybe one day we can invite one of our people that might know, namely this fellow right here, to join us to explain their rationale for why they're not doing CECs and what their plan and strategy is for the hundreds and hundreds and hundreds of thousands of international workers, well, basically international graduates who are on open work permits, who are languishing with no pathway to permanent residence. So, Minister Miller, we are waiting to see what your plan is, because your predecessor, this fellow right here, Sean Fraser, he had heralded the whole time throughout his tenure the importance of international students to the future of Canada and our economic well-being. Well, Minister Fraser has moved on to now a different portfolio. The reality is they are suffering, and we're seeing absolutely nothing that is truly opening up pathways for them in meaningful ways. So I guess we'll see what what Minister Miller has in store. But at this stage, there's a lot wanting, for sure. All right, let's see who else we've got here. We've got Nihal. Hello, Nihal. Good to see you. Kathan is over in Saskatoon. What's the weather like in Saskatoon, Kathan? I wonder if the snow is flying like it is here. I was looking. Let's see. I was looking at my phone, Alicia, just earlier before jumping on the call, and so down here it's about minus 14, between minus 10, minus 14 and in the southern part of Alberta. But I was looking in Ottawa, it's like 15 degrees. It's still summer there. Although there is, it looks like it's raining. It looks like the east is faring a little bit better than us out here in the west with our snowfall warning. So we will see. Yeah, well, I guess we'll see, but it sure looks like winter's here. Okay. Hey, Collins. We'll give a shout out to Collins. First time here. Great to have you, Collins. All right. Let's see what else we have here. And those of you who are posting your questions, we'll definitely go back and we'll hit on all of them. Let's see here. Catherine says, same like Calgary, snow and cold. Yes, it is definitely a time of snow and cold. Okay, let's jump into some questions. Let's pull up our first question. This one is from Sakar. Being a provincial nominee, can I stay in the province and work for the organization in the US or from the different province? Will it cause any problems in the future? Thanks. So I think what they're talking about is remote work while still living in the province.
Mm-hmm. And so this is a tricky one. And of course, I'm not going to give specific immigration legal advice, but we can talk about legal information in general. And one of the important things is that if you are a provincial nominee, it depends quite a lot on what category of provincial nomination you received. So a lot of these provincial nominee applications are employer specific. And so many times you have to prove that you have an employer in your province, the province that nominated you, and they wrote a support letter, and sometimes they even did a declaration as part of your application for the PNP. If that's the case, and you said to the PNP that you were working for a particular, BC-based employer, let's say, under a BC nomination, then it's important that you notify them if you change employers. That's only fair. That's only being honest. And it could jeopardize your application if you change employers. Now, some of the provincial nominations are not employer specific, so some of them don't require that specific support from a particular employer in the province. But you do have to have a valid intent to stay in that province. And so there might be an argument to be made that you're physically residing in that province, your kids are going to school there, maybe your spouse is working in that province, and you've, for whatever reason, needed to take a remote job. hopefully you're taking a remote job for something outside of Canada and it's not, another province and you look like you're moving to another province within Canada. But there might be a reasonable argument in some circumstances to say, I'm physically residing, I have a long-term lease, or I've bought property in this province, kids are going to school, we're established, spouse is working here. I needed to take a remote job, and that might be reasonable, but it is something that if there's a material change in circumstances from when you submitted your PNP application or your EAPR, if it was express entry linked, then you have an obligation to notify IRCC and probably the province as well of material changes to your employment situation.
Yes. I just want to pull up one comment here. Okay. Okay, these ones here, we've got a few that are kind of related to a spousal, which it's great that we have those because we do a lot of these. But Gumi says, I'm in a long distance relationship with my girlfriend the past 5 years. She is a citizen and I'm from India. So I'm assuming a Canadian citizen. If I get married, can she directly sponsor for permanent residence or do I need to go through an open work permit? So this is a real big misconception. We see people confusing the two, spousal work permit and spousal sponsorship. Do you want to kind of shed a little bit of light on that, Alicia?
Yeah, so normally someone is able to sponsor if they are a Canadian citizen or a permanent resident living in Canada. That's an important part of it. And they can only sponsor a common law partner, meaning that you've lived together continuously, cohabitation for 12 months. And if you're in a long distance relationship, that doesn't seem like it's going to work, unless at some point in the recent past, within those 5 years, you actually had 1 year of physically living together as husband and wife. But if that's not the case, then you need to have a legal marriage, and that marriage has to be legal in the place that it's performed. So whether it's in India or whether it's in Canada, as long as that marriage is a legal marriage, then that is what you need to be able to submit an application. But you also need to prove that it's going to be a genuine application. So that's where you have to have letters of support from friends and family. This marriage is in line with, your values and your backgrounds and your education histories and all these things for both of you. What happens when you do a spousal sponsorship is it's a permanent resident application. So the Canadian who's sponsoring would be basically undertaking to the Canadian government to say, I'm sponsoring this person and I'm going to be responsible for them financially, usually for 3 years after they get PR. It is a sponsorship. It's not a temporary residence application. It's for permanent residence. What makes it a bit complicated is that in some circumstances, you can also apply for an open work permit if that sponsorship has been submitted. In the past, historically, it used to be only if you qualified under the spouse or common law partner inside of Canada class. So keep in mind there's an outside Canada family class spousal sponsorship and an inside Canada spousal sponsorship. In the past, you had to be physically present inside Canada with valid status before you could apply for that open work permit once the spousal was submitted. Immigration has, changed the rules a little bit around this, and so theoretically, more people should be eligible for that spousal work permit. Take a look at this article that I wrote. This is kind of the difference between inside and outside Canada spousal sponsorships. There are benefits and risks to both of them. You can take a look at the website for current processing times, but the big one is that if you do an outside Canada spousal sponsorship, you should have a right of appeal if for some reason immigration doesn't believe that it's a genuine marriage. If you do an inside Canada spousal sponsorship, there's no right of appeal. The other thing that people get confused about is that you can be physically outside of Canada and come as a visitor in the meantime and still do an outside Canada spousal sponsorship. So the fact that you physically come to Canada, if you happen to get a valid permit in the meantime, doesn't invalidate your outside Canada spousal sponsorship. It's usually the best way to go. But if you do an inside Canada spousal sponsorship and you lose your status or you leave Canada, theoretically that could jeopardize your spousal, the PR application. So there's a lot of things to consider about spousal sponsorships
Yeah.
inside Canada, outside Canada, and whether you can work or visit in the meantime.
Yeah. I think, Alicia, I think what we should do is a special live for just spousal sponsorships. There's so much to unpack with that. I think many of you know, or if you don't know, we have on the Canadian Immigration Institute there's a DIY course for spousal sponsorships that you should check out. I was digging through some of the other comments, and Gummy here is watching live from the Wonders of Seas, world's largest cruise ship. So that's the first time we've had someone connecting on the live while they're at sea. So that very cool. Thanks for sharing that. You bet. Thumbs up. Okay, I'm actually going to pull this one up, Alicia, because Argentech Immigration here, Adriana, I was not able to connect with you this morning. My apologies. I had a whole bunch of things that I was trying to get through. And Argentech here is an immigration consultant. She says, good morning, 6 degrees in BC. That's pretty cold for BC. Looking for tips for a good restoration of status submission. Got a refusal for not submitting an LOA. Actually submitted remedies in case of refusal. Thanks. So I'm not exactly sure what all the questions are here, but yeah, letter of admission, I'm assuming within the context of an application. It's so hard. And this is one of the reasons why Alicia and I, we really don't use assistants or paralegals in the context of reviewing applications anymore. We work directly with our clients together to make sure that nothing gets missed. And it's so easy because IRCC is absolutely ruthless with these applications. Anything that's missed, it's way easier to just return the application than request something that's missing. So I don't know if you have any thoughts, Alicia, on this topic, which, is a very, very real one these days.
Yeah, and so the first thing I would say is sometimes it's not a restoration that you want to be doing only. You want to also be filing or having your clients file an application for leave for judicial review to federal court. And it's really important that you do that right away, especially if you're an immigration consultant. You're not allowed to go to federal court. So have your client talk to a proper immigration lawyer in Canada who can file that application for the client to make sure that they preserve their potential rights of having a real remedy, because immigration may not give that restoration of status. It's discretionary and it could depend on a number of factors. And so if their status is key, and if that letter of acceptance was actually submitted properly and it was an error on IRCC's part, then it might be really, really important to make sure that that application for leave and judicial review is filed right away, and it has to be filed within 15 days of the refusal. So be very careful to make sure that your client is doing everything that they can to try to get a good remedy here, and that might be asking for restoration, but also having an application for leave to federal court if there was an error on IRCC's part.
Yes, and I'll just slide over here to our website as well, you guys. If you go up here to legal help, you'll see that we have a lot of resources on refused applications, the JR process, reconsideration requests, delayed applications, writs of mandamus, misrep. So you can learn a lot more about these different processes and what you do in the case of refusal through some of the content that we have on our website. So definitely go and check that out. And Adriana will hopefully be able to connect with you to help sort out that issue with you. Okay, Manswe here's got a super chat. So here's the question. I have my e-Coper, but not my permanent resident card. I'd like to modify my legal names. I have 2 first names. I would like to remove one and keep only one. This change has already been effected on my passport. Then it goes on, how would you advise I go about this? Do you have an IRCC site I can refer for this procedure? Alicia's just pulling it up for us here. And is it sufficient to submit only my international passport as proof of the name change, or are there other documents needed? So while Alicia is pulling that up, we'll definitely slide over Manswe, and I'll pull up that site and we'll just share it with you. Just give me 1 second here. All right, so we'll come back to that one in a bit. Here is, let's pull it up and I'll flip it over. Okay, so IRCC does have, and you can just search for this title. So naming procedures, managing existing records, change of name request. Okay, and so there's the basic general guidelines, and it will give you clear explanations as to what they want to see. So you can take a look at all the parameters when it comes to making changes to your immigration documents. All right. Okay,
And
let's.
I will say
Yes,
it is
mhm,
tricky. It is
it
not a
is.
straightforward thing. I'm glad that you said that your name change was properly done on your passport because normally immigration in Canada will lock everything in with what your passport says. And so if you landed already on the old version of your name on an old passport, now you changed your passport, they might say, too bad, it wasn't a clerical error and it was a correct at the time that you did it. So be prepared for some pushback.
Absolutely. And if you need any assistance, Mansfi, obviously, we've talked about this a lot. When you go to our website, if you need extra help, please don't hesitate to click on Speak to a Lawyer. And when you're here, you have the ability to book a consult with myself, Alicia, or anyone. And I was just going through some of the more recent reviews, and yeah, we just so people are so kind, Alicia. We received an awesome one that's not showing up here just the other day, but yeah, Abhishek and Shiva, and we've had a bunch of just really, really kind reviews from people. I did see, Alicia, that we had a 3-star one that popped up. I don't know if I can pull it up, but it just had 2 letters. It was like SW and nothing. And so I'm always so mindful of these reviews that people leave. And anytime someone leaves anything but a 5-star review, I always want to connect with the person and find out how we can do better. We are not perfect, and sometimes clients leave the consult feeling like, well, that wasn't very helpful. They didn't tell me how to fix my problem. And that's one of the challenges that we face as immigration lawyers. Sometimes people get themselves so far into problems that we can't fix it. And I had a consult earlier, actually yesterday, with a client that basically I had to tell him that he needed to go home. There was no real meaningful pathway of being able to stay because of decisions that he had made. So sometimes we can't have, there isn't a nice, easy solution. But one thing you can always rest assured that we're going to help you to understand where you're really at and where the real possibilities exist. And sometimes the answer is you have to go home. And other times there are things that can be done. So that is what we have.
Yeah, and this is the thing. We're going to be honest, right? We might not tell you the answer that you would love to hear, but we'll tell you the answer that maybe you need to hear because that's what legally is correct. And so I don't like being the bad guy, but I do,
No.
integrity is everything. And I can't tell somebody a rosy story when it's something that is not so rosy.
Absolutely. I'm going to pull up Collins here. And Collins, I'm going to right away ring this bell because I highly recommend you book a consult with us immediately. So Collins says, what's the chances of responding to a procedural fairness letter and avoiding being banned and instead get the visa approval when basically they have not declared the visa a prior visa refusal? And so it is possible to save these. It is in some cases, it is possible. But we strongly encourage that you book a consult so that we can go through everything and really understand what happened. But the fact that they've given you a procedural fairness letter at least gives you a chance to respond, which that's when we love to connect with people. What's really hard is when people have responded and then got the refusal. And then there's, at that stage, the options are really, really limited in what you can do. So Collins, I recommend that you slide over and that you do consider booking a consult.
And I will add too that this is serious, right? So this is one of the reasons where immigration officers are very, very particular. If you have a failed or refused entry, or you were traveling on a school trip when you were a minor to the U.S. and you didn't remember that your visa got refused, and you do not disclose that on your application, it has been found by the federal court to be misrepresentation, and it's very, very serious. And they've upheld it as a valid refusal and a valid ground for misrep. And if they find that you've misrepresented, you're barred for 5 years, which is the worst case outcome. So we actually even more love working with people before they go and file their
Yeah.
applications and then they realize, oh, I forgot to disclose this. I always sit down with people and say, are you sure? In the past, did you ever file an application to Canada or any other country around the world that was ever refused or denied, or you
Yes.
weren't allowed entry ever? And, go check with your parents, go check your records, make sure before you file that application.
Yes. Great advice. All right. Next question is from Nita. And this also is a complex family in the area of the family class. Nita says, shall I face immigration complexities due to ongoing divorce, plus zero sons documents? So they're trying to wedge everything into a single. I'll try to decipher this. I'm assuming zero sons documents, medical, but desire to immigrate with my current common law spouse. So I have no intent to sponsor separated wife and son. So Nita, in this situation, I think what's happened here is they want to become either a dependent of as a principal applicant with another person's a common law spouse's permanent resident application, or they themselves are the principal applicant, but they have a child from a prior relationship. They're, being still married. I'll let you talk about the ability to proceed as common law when you're still married, but this is something I had a consult with just yesterday. A couple whose application was rejected, in this case, because the consultant they hired didn't include that child as a dependent when they were an actual biological child of the accompanying spouse, but with another relationship with another woman in Africa. And even though the person had no contact with that child, the decision was made by the consultant not to include them as a dependent. So in their case, their application got rejected as being incomplete for not including the documents for the dependent. And it's really sad, Alicia, too, in that situation, because they got an ITA with, I think, a 496, and she just had a birthday. So now she's down to, actually, I think it was 495 or 494, because now she's in the 480s. And I don't know if she's going to get another invitation to apply. But notwithstanding that, of course, you're gonna list as dependents all children that are actual dependents. But then you run into the issue, Alicia, where there's an uncooperative spouse who, or an uncooperative, other, biological parent who has custody, or the child lives with them and they refuse to cooperate. So this is a whole podcast in and of itself, but what are your initial thoughts for Nita here, Alicia?
Yeah. And just like you said, Mark, there is almost no point in trying to pursue your immigration objectives if you haven't first dealt with all of your family situation. And so sometimes this involves divorce lawyers, sometimes this involves attorneys from other countries to make sure that those divorces actually get finalized. Sometimes you need to have court orders. But basically, from immigration's perspective, when they are examining the principal applicant, they must examine all related family members. So any children who are under the age of 22 who are a dependent child of that principal applicant, biological child, regardless of whether that child is in somebody else's custody. And also, if there's a legal marriage still in place, right, if that divorce is not finalized, then that person is still technically a spouse. And immigration has to examine them medically to make sure they're not medically inadmissible, and also their criminality to make sure they're not criminally inadmissible. Because if you have a dependent child or a spouse that is medically or criminally or inadmissible for misrep, that's going to make the principal applicant inadmissible. And what happens is if you try to cut those people out, for some reason, you manage to get your application as the principal applicant to proceed, and you manage to show the court order saying, I'm never going to sponsor this kid, and we all know what's going on, and the kid's getting older and they can make their own choices, then be aware that that child is forever considered not to be a member of your family class under 117 sub 9 sub D. So this is really serious. I know there's been circumstances where, the spouse that has custody dies unexpectedly, and now you have a kid who you can never sponsor. So these are really complicated situations. The other issue that Mark alluded to is common law spouses. It's very complex. In general, you cannot be sponsored or an accompanying applicant on a common law application if you're legally married to somebody else, in general. So just keep that in mind as well.
Perfect. All right. I'm getting some helpful hints here, Alicia, from all fronts. So Metab says, Mark, you're staying up too late again. Rest, rest. You're right, Metab. I am staying up too late. It's true. Here's the challenge. My children are night owls, and when they come home from their activities, they like to come into our bedroom and visit with us. And so I usually spend, an hour or so visiting with my adult children about their various dating relationships or activities. My son, Adam, I wish I could show it. He is, if he sees something that he wants to do, and it's not currently offered in wherever he lives, he basically creates it or starts it. So he got into this country swing dancing when he was down in Rexburg in Idaho when he was at school. So he really enjoyed it, and so he came up and he started this swing dancing, activity with the young, I guess we'd call them single adults here in Lethbridge. And I think the other day he had over 100 kids that were coming out to the church and the gym, and were learning how to swing dance. And it was quite funny the other day, Alicia, because he was showing me on his Instagram where one of the songs that he'd used as the background music for a video showing all the people dancing. The artist actually reached out and gave him a shout out, and said that if this is where you should go to learn to swing dance. And so it's really cool. So Mitab, when you have adult children and they are not yet married, be prepared to stay up quite late every evening. So that's me. Okay, now Mitab did have a question, Alicia. And Mitab says, after receiving the stamp for the Canada H1B visa, so I'm assuming passport, it's ready to go, can it be denied at entry based on the India-Canada recent relations?
Okay, so yeah, this is an evolving situation. So far, Canada is not doing anything retaliatory as far as I'm aware. They are still honoring everything that they have already approved. So if you have an H1B visa counterfoil in your passport and you haven't yet come to get the work permit, I've had a few consults on this, Mark, and it is tricky because sometimes when you're on that H1B status, you can't leave, right? As soon as you leave the US, you've lost your ability to re-enter the US, so you really need to be sure that you have some place to go in Canada. Technically, you don't have to have a job offer in order to be, eligible under H1B. You have an open work permit, but a lot of people really want to know that they have a job to go to in Canada, and so they're trying to figure out, when do I leave the US? When do I come to Canada? That work permit isn't actually valid, of course, until you arrive at the border and you get that work permit issued. And only then do you actually have the document in hand that you can use to come in and out of Canada with that multiple entry visa. So it is a bit tricky. Technically, an officer could decide not to give you that work permit if you no longer meet the eligibility requirements of the H1B category. So, if you're not resident in the US anymore, if you don't qualify as an H1B holder, those things are important that you maintain if you don't have your work permit yet from Canada. So make sure that you still meet the eligibility requirements for the H1B category itself. And then once you have your work permit, you're good, you've got your work permit. But so far, we are not seeing anything where the Canadian immigration authorities are saying we're not going to honor that. It's only if you don't meet the eligibility requirements for the program.
Yes. And on that note, Travel with Camby says, Mark, make a visit to India someday. There are millions of prospective students aspiring to study in Canada. It could be a great deal of business. It could be a great deal of business for you, essentially. Yeah. Well, maybe one day, but I will definitely wait for everything to settle down between Canada and India before I make any trips there. But it was something that was on the radar for sure, Camby. So thanks for that. Here's an interesting question, Alicia. This is from Hader. So Hader says, hey, Mark, how is Lethbridge? I heard crime rates are high. We're planning to move there next year, but wanted to hear from a local. Okay, well, obviously, I've got friends that are on the force, and the city does a really good job of not broadcasting or posting or throwing up in the media every little thing that happens in the city. But I can tell you from my own personal experience that there was a time when, yes, I was very frustrated with especially break-in enters and things like that, and theft. I don't want to get, maybe I shouldn't say much. There was something that happened in the city that really brought a lot of people in that were really struggling and had various drug addictions and things like that. And there was a lot of theft as a result of those factors. And it was very rarely was it any kind of violent crime. It was just bikes getting stolen and things, and people just, what happens? Like anyone who's suffering from any kind of, mental problems or are in distress in their lives or in down situations, who feel hopeless and lost, they do whatever they can to survive. And so there's a lot of people that came to Lethbridge because we had a a place here. I want to keep it kind of vague. And so a lot of people came that really needed a lot of support, and the community just didn't offer it to them. They didn't have the support they needed. All they gave them was a safe place to take their drugs, essentially. And because of that, a lot of people that came, there was just a lot of break-in and enters. They needed to feed themselves. It's nice to have a place where you're safe and you can be, the medical care is there for you. But at the end of the day, there was just a real lack of support for the volume of people that came in. So, but that is now since closed and it's not around anymore. And it's just nowhere near where it was before. So in terms of crime rates being high, I can say from a local that I don't see it at all anywhere. So there's a long, convoluted response, and I have to be very careful how you describe things. I have my own personal opinions on things, but really, at the end of the day, I love my city. It is super safe, and it's a wonderful place to live and raise a family. So, when you compare it to a lot of other centers in the world, Lethbridge is a pretty safe place. So just us and the deer, walking around the roads, and the animals, and it's quite amazing, actually, Alicia, how many critters are roaming around the city. It's really cool. All right, there you go, Hater. The long, convoluted question. Alicia's like, Mark, don't say anything. Just don't talk about that. Yeah.
Well,
So.
I was also a bit distracted, Mark, because as you were talking, literally a coyote was walking across the street. So I was a bit distracted.
That's awesome. That is awesome. Okay, let's jump to a few more questions here. So this one's from Natalia. She says, "Good morning from Vancouver. Why do you think e-copers are being delayed for many applications? I'm now waiting for more than 1 month. How does this process work at the visa office?" Ugh. Oh boy. I don't know. You want to try to answer that, Alicia? Yeah.
Okay, here's my attempt at an answer for that, Natalia. The nice thing about the fact that immigration is trying to speed things up and trying to process it is that they are trying to finalize applications. So we are seeing more notices that, passport requests and send things in, and we're almost finished. Once that's in, really that very last step is immigration sending that e-coper, having it signed off, and then you making sure that you do everything through the portal so that you get your PR card. Keep in mind that the moment you become a Canadian permanent resident is when that e-coper is signed and everything is correct. So right from there, you are a Canadian permanent resident, but of course you can't travel because you don't have that PR card, and that is also taking a while. I'm hopeful that that will get the kinks will get ironed out and that process will become much more smooth and streamlined, because it is keeping people on tenterhooks, right? They're waiting. They don't know what's going on. They can't really continue with their lives until they make sure that they have that e-coper signed and they know that they have permanent resident status. So it does seem right now that things are being rejigged within immigration processing streams. So we'll have to see how that shakes out. But yes, there is definitely room for improvement in terms of making transparent what's going on people's applications.
Yes. All right. Next question. This is one that I'll tackle, Alicia. It's a port of entry question. So Mega says, "I see Terminal 3 for international flights and other terminals for flights coming from the US. Is it okay if we go to different officers on the same day or 1 day apart?" So this is me looking through the question to see what really the issue is. So I'm assuming, Mega, that you probably got a decision that you really didn't want, whether it was a refusal or asked to leave. Port shopping is what we kind of called it on the street as border officers. Port shopping, looking for a better decision from a different officer, is not something that we encourage. Officers can see exactly if something bad happened to you. They've got your record. The moment they pull up your passport, they can see the history, and they don't like it when people are told one thing and then they try to go somewhere else for a better result. However, with that being said, Mega, depending upon the circumstances, absolutely, there can be times and possibilities, if properly disclosed, where you can seek a different answer from a different decision maker. I'll give you an example. So I had a couple that they were in Canada and they'd done everything they were supposed to do, except they forgot, and largely attributed to the pandemic and issues with it, to extend the stay of their young 10-year-old daughter. Well, she had fallen out of status, and not only out of status, when they applied to restore, they were beyond the 90 days. And then IRCC, because of the pandemic and whatever else, took over a year to refuse the application, which should have been refused right away. So the child was really out of status. And so they were from Japan, I think. I can't remember. I think it was Japan. And so the question was, do we go down, to the port of entry? What do we do? Because realistically, trying to rectify it from within Canada would have been a real pain. So I directed them, after lots of discussion, to go down, and they were in the Maritimes, in Atlantic Canada. I directed them to go down to the border to leave and then re-enter and explain the situation to an officer. Unfortunately for them, they went straight to the immigration office, and they didn't quite follow my instructions carefully. And so they didn't leave and re-enter. And the moment a person goes directly to the Canadian office seeking any type of a visa, at least the border service officer on the Canadian side, without actually having left and then re-entered, the officers will rarely facilitate, and they also won't tell people to actually leave and go down. So we faced a problem that, they had another young child that was with him, and, that was crying, and it was just a horrible situation, a 2.5-hour drive from their home. So we made the decision to leave and to go back home, and then the next day return. But we did not go to a different port of entry. We went right back to the same place where they had rejected them the day before, but we made sure that everything was disclosed, and they left and re-entered, and we were able to get the permit, and that was at the same port of entry. But sometimes different ports of entry can be more difficult than others in terms of how they, apply immigration law, and how they determine, whether or not to even process. And we know that in some, Ontario ports of entry, they have certain days that they will process applications, and others they won't. At the airports, generally speaking, when you appear, they will adjudicate your application. But if you didn't like the decision that you got at the international terminal, Terminal 3, and then you're thinking, okay, well, we'll fly to the US and then fly back into a different terminal, it may be possible, but I strongly encourage that you seek some legal advice before you do that, and that everything is very carefully documented and properly prepared in a way that the next officer who's looking at it is fully aware of the previous officer's decision, and that you've got some new or additional evidence to make the actual adjudication something different in kind. So that's my advice, having worked on the border as an officer. And I'd encourage you, Mega, to actually look at booking a consult and working through that process. Maybe you already have counsel, and hopefully they're giving you advice, but I guess you wouldn't be posting a comment here on our live Q&A if you had retained counsel to assist you. Okay, let's see here. Mohammed says, good to see you, Mark and Alicia. With regards to the H1B open work permit, have you heard if folks got a full 3-year permit at POE, or if it has the same validity as the letter of introduction? And Alicia, have you had anyone that has received an approval? Maybe if people have, I'd welcome, reports from people. But you know what? It's interesting, Alicia, because a lot of people that have applied, many have not even used those permits yet. They're just holding them in their, keeping them in their back pocket in case something goes south in the States that would require them to come to Canada. So I wonder how many are actually traveling.
I have had a few people travel and say that they have their valid H1B work permits now, but I don't know, I've never heard them say that they didn't get their full 3 years. The only circumstances where I know you would not for sure get your full 3 years is if your passport was expiring earlier. So if your passport's only valid for, 2 years and 2 months, your work permit's only going to be valid for 2 years and 2 months. So just keep that in mind as well. And Mark, I did want to also talk about, there's Romina Casas Corderos Niga has a question about a PNP application submitted under Express Entry, and then their work permits expiring in 3 months. So I also wanted to touch on that one too.
Okay, so Romina says, I heard that flagpulling won't be accepted anymore for people applying for a work permit inside Canada, and the border services won't be issuing work permits for people coming from outside Canada by air. Is that true?
And then she also asked a couple questions up about
So my husband and I applied for permanent residence 5.5 months ago. Our work permit will expire in 3 months. What would you recommend doing to keep our status?
So be very careful, Romina. When you have filed a complete application, EAPR, so I assume that you had a nomination from one of the provinces and you got an ITA and you submitted your full express entry EAPR electronic application for permanent residence. If that happened and it's all done, it's all complete, and your work permit's going to expire in 3 months, you should apply online for a bridging work permit. Now, be really careful because some of those bridging work permits are employer specific. If you did a PNP nomination that actually has employer conditions. So take a look at your nomination letter and it will say whether there's an employment restriction on it, yes or no, and it'll sometimes say the employer name as well. Just because it has the employer name doesn't necessarily mean it's employer restricted, but if it says yes, employer restricted, then you need to apply not for an open bridging work permit, but for an employer specific bridging work permit. So be really careful. There are program directions online. IRCC has a whole section. If you look up IRCC and bridging work permits, there's a whole section on PNP applications and whether it's employment restricted or not and how to make that application. But reach out, book a consult, and we can help you with filing an application for a work permit extension under one of those PNP nominations with the bridging work permit. And you have to make sure you're doing it correctly for you. And then I'm assuming your spouse was an accompanying family member under your PR application. So if that's the case, then you can do an application to extend for both of you or change conditions to that bridging.
You bet.
But you don't want to
Okay.
go down to the flagpole to try
Yeah.
to go and do anything at
Yeah.
the border.
Yeah, exactly. Colin says, thank you. You're very, very welcome, Colin, for your question. Okay, Alicia says, how many years of experience do I need to qualify for a PNP draw? I already have an Ontario nomination. So this is kind of an interesting question, Alicia. I'm not sure exactly what you're asking here. If you have the nomination, I'm assuming you have established sufficient years of experience. However, sometimes, and maybe I'll just address this one and then we'll move on. Sometimes people will indicate certain things in their application and not necessarily have all of the evidence to prove it. So it's like the profile for express entry. You can put whatever you want in there and it'll generate an ITA if you answer the questions in a certain fashion. But if it's not true and you can't prove it, then it's not going to help you in any way, shape, or form. So be aware from that. I don't know, Alicia, if you can pull
Yeah,
anything out of that.
what I would say is it is confusing because many of the PNP application categories are express entry linked, right? So there's PNP applications that are express entry linked, meaning you have to have a valid federal express entry profile number, which then allows the PNP to see you, and then they issue you the invitation, and then once they nominate you, once you get the federal ITA, then you finalize everything through the express entry portal. But there are some PNP applications that are not express entry linked, and so that one you're going to do through the general PR portal after you get your nomination. There's different sets of rules for the PNP applications in terms of how many years of experience you have to prove to meet the category points under that particular PNP category. And that is often different or could be different than what the federal express entry minimum requirements are in terms of meeting those 67 selection points if you're looking at FSW, or if you're looking at CEC points in terms of calculating your work experience CRS. So they're two different kind of point systems, and you have to go and take a look at the program requirements for the PNP category that you applied for. Be very careful. Almost every province has all of their manuals online. Sometimes there's unwritten rules that you have to talk about directly with the province to make sure that you're doing it according to their new procedure.
Exactly. All right, this one's from Yuander, and he says, is it possible to apply in the AOSPNP Alberta using the closed work permit? Well, Yuander, if you have a closed work permit, that's a specific type of work permit that the province actually likes to nominate, provided you are living and working for an Alberta placed, an Alberta focused or located employer. So so the answer is yes. It's the open work permits, the postgrads, the spousals. Postgrads have a more strict approach. You have to have actually needed to have studied in a related field, in Alberta before you're eligible, generally speaking. And other open work permits, spousals, et cetera, that are truly open, you can't apply. You're not eligible. So closed work permits, yes, is definitely something that can potentially give you a possibility.
Yeah, just one wrinkle on that. I did attend
Mhm.
the Canadian Bar Association had a session with Alberta Immigrant Nominee Program. They came and
Mhm.
all their program officers, as well as the director, gave a presentation last week on Wednesday. And they did say sometimes there was some wiggle room on the website, like there was some ambiguity about which categories of work permit would be eligible under which program. They said that they have now updated that. So on their website, it will specifically say which categories of work permit holders are eligible for AOS, whereas it wasn't quite clear before, but now it should be. If you're not on that list, you're not eligible to apply. I do know there are some closed work permits that are seasonal, for example, like seasonal agricultural workers, and those ones, you'd have to be really careful about those. But in general, Mark is correct that if you have an employer-specific work permit, as long as it's a high-skilled job and it's permanent full-time, then those ones are normally perfectly fine. But do take a look at the list online.
All right, next question. We're just about done here. 5 more minutes. So Olufemi says, I'm currently working on a part-time basis in Ontario. Can I apply for Canadian Experience class? So I can hit that one quick, Alicia. So as long as it's skilled and your part-time is at least 15 hours a week and it's paid and it's tier 3 or higher, that generally that you're going to be fine. It's just it'll take you at a part-time basis working at least 15 hours. It'll take you 2 years to meet the minimum eligibility, as compared to someone who's maybe working full-time or at least that minimum 30 hours a week. They can do it in 1 year. So if you otherwise meet all of the requirements, then there's nothing stopping you from being eligible to submit an express entry profile through the Canadian Experience class with that minimum 1 year, as long as you have the other, language, etc. All right. Okay. Gumi says here, and this maybe we'll hit on this carefully. And this actually comes back to the fact that more recently here, if we flip over here, you can see we have had a round of invitations for transport occupations right here. And that occupation within there, sometimes individuals, in the case of Gumi here, might qualify. Now, I don't know if that's the program you were drawn under or where you're at, but Gumi says, as a mariner, how to show travel history after the ITA. Should I include all the ports to which my ship went, or I only need to mention travel dates and country which are stamped on the passport? This is a great question that every time we have individuals that work at sea or are on cruise ships or things like that, we have to deal with because it can be a real mess. So in a short response, Gumi, I highly recommend that you book a consult with us and let us help you to work through that. But Alicia, like short little snippet, what do you think? What do you typically advise people in these circumstances?
Yeah. So give me, I normally sit down with my clients and I look at the whole thing and I say, okay, give me a spreadsheet, right? So give me your passport with all your stamps. Give me, usually there's like a manifest, a ship's log, that says where you're posted or what your schedule is for each of these places. Sometimes that'll be, the company has records that you can go back and cross-reference. Sometimes it's exit entry histories that you can get from various countries, but probably you're going to be sitting down and doing a spreadsheet, and you're going to put every country and when you entered and when you exited and what the dates were. And if you need to update that, as you go, then you can keep a running total of it so that if immigration asks you for further updates, you have it. But yeah, after ITA, you still have to do everything up until the day you submit your EAPR application. So keep track of it all to the best of your ability. It's always a bit of a judgment call depending on how long you were in each place, whether you put that as a short trip and whether it changes your address. I don't know if you're on the ships for months and months, but there's always this kind of dance between your travel history and your address history. So just be careful with that.
I'll just pull up Ramina's question, her second two-part question. We only answered the one about heard that flagpulling won't be accepted anymore for people applying for work permit inside Canada, and that border services won't be issuing work permits for people coming from outside Canada by air. Is that true? I can't see any world, unless there were massive overhauling of the whole immigration program that would lead to this result. Alicia and I are doing podcasts right now where, treaties that we have, trade agreements with different countries, if they're visa exempt, those individuals, one of the advantages is that they can come and apply for their work permits directly at a port of entry by air when they're flying in, whether that's American citizens or Mexican citizens or other countries. So, but flag polling is a different question. Flag polling is when an individual is in Canada and they leave and then seek to re-enter. Like that example that I gave of the family with the daughter who had expired status in Canada, that would have been considered a flagpole. But some ports of entry are very reluctant because they're trying to cut down the flow and the volume of applications they're facing. They will restrict people to a certain time of day, certain days of the week. And those more strict measures are put in place to curb the volume of people that are seeking to go to apply for their work permits at the port of entry because they're looking at 5 months processing inside Canada. So Alicia, I don't know if you have any intel or if you've heard anything on this, but other than what we've already seen and some ports of entry, starting to institute specific times to do that, have you heard anything else other than what's
Well,
already in existence?
I mean, what I would say, and people often don't realize this, is if you are flagpulling, it means, as Mark said, you are actually legally entering the US. And if you don't have a US visitor visa and you need one because of the type of passport you hold based on your citizenship, then you are in potentially really big trouble, right? If you try to enter the US and you have no proper legal ability to enter the US, now you can be in really deep water because now you are potentially breaking a few countries' rules, and that could land you in big trouble. So just, you know,
Yeah.
flagpulling always has risks. Also, if you currently have a work permit, and Romina, you said you guys have your EAPR, you've got your PR application submitted, I would be very reluctant to tell somebody to leave the country and to try to come back in if there's anything that could go sideways on their application, and an officer could make a decision to cancel their permit, and that could jeopardize their PR application. So, if you can do an online application and just extend your status and you continue to have implied status to work while that new work permit application is being processed, that generally is a much safer way to go.
Right. And just understand that different ports of entry treat those entries to the US differently. So, some ports of entry, when you don't have a visa to the US and you present yourself on the US side and say, I don't really want to come in. I'm not seeking entry. I'm just looking to apply for a work permit. So, can you just turn me around and point me in the other direction? Some ports of entry will treat that as an actual entry and they will say, okay, well, you got to come in. We're formally going to refuse your entry because you don't have a visa. And then you have a record with the US Immigration Authority. And then if you try to apply to go down there later or for, a visit or whatever, as a business visitor visa, you're then in a situation where you may have a strike against you that can prevent you from being able to come in, all because you presented yourself. Now, do people do it? They do it all the time, probably not understanding the true consequences of making those requests to enter. If you have a visa to the US, then you have a much more a more facilitative process than someone who doesn't and needs one. So just be aware of it. And you can look online, you can see, there's lots of people that have come and done that and successfully got their work permits, but just be careful because there could be hidden ramifications that you're just not aware of, and that could happen, it could pop up to bite you later on.
And I will add one
Mhm.
last story because I know we're over
Sure.
time, but I did have a case where somebody received a procedural fairness letter and their whole application for permanent residence was about to be refused. And it said, you failed to disclose a refusal from the US, right? So what had happened was they were in Canada, they went down to Flagpole, the US didn't let them in, right? But when so they were in that in between no man's land, right? The US didn't let them in, but they went back to the Canadian side and Canada actually gave them their work permit and the study permit for their child. And so in their mind, they were like, oh, we're good. Our permits were
Yeah.
approved. So they filed their PR application and they did not disclose the fact that the US refused them entry to the US on that little trip. And
Yeah.
now their whole application for PR is at risk because immigration in Canada is saying they misrepresented. So be really careful about that.
And I'm going to give Alicia some applause for that because that is something no one talks about, which is a real concern. No one is talking about that. So thanks, Alicia. I'm glad that you brought that up. So rule of thumb, if you do go down and you did seek entry and were turned back on those questions, you don't always know ultimately what the decision was made on the US side. So if you need to do some investigation, see if you can, pull up your record if you're uncertain, or out of an abundance of caution, just identify it and say, this happened at one point in time. I'm not sure if it was an official refusal, but I was, turned around when I flagpulled. And that's the best way to handle it. No matter what the ultimate decision of the US was, you just disclose it out of an abundance of caution. All right, and then I'll wrap up here with an express entry one. Daniela says, hey, Mark and Alicia, when the express entry profile is about to expire, do I have to withdraw before opening a new one, or the old one will be deleted by itself on the day it's supposed to expire? So tackling that at the very highest level, most IRCC secure accounts will only allow you to have one profile active at a time. So anyone who decides I'm going to create another profile literally has to go back and create a new GC key account and set it up that way. But when it comes to a profile that's expiring, you can choose to withdraw it and then submit another one right away. But when it comes to the profile, once it hits the 1 year, it will automatically expire and time out. So there's nothing that you technically have to do, but you won't be able to submit through your same GC key a second profile through that same key. And I would advise you not to create a new GC key, but I would I'd advise you, if you didn't think you were going to get drawn, or you could create a new profile right away, then just do it. Don't wait. All right. Anything else? Any last thoughts, comments, Alicia, as we wrap up here?
I think, I guess the last thing I'll say is just to hang in there, right? I know that it's always changing, and there's a lot of news right now, and things might get slower processing because of what's happening with the visa processing post in India. But hang in there. We're in this with you guys, and we're wishing you the best in your applications and your immigration journey.
Exactly. And I guess I'll just throw out one last thing. All of you who are here from Ukraine, the permanent residence for Ukrainian nationals with family members in Canada is now out there. And Igor is releasing lots of content on this topic. So check out some of the things that we have on our website, and I think there's maybe some blog posts, but Igor's been producing a lot of content. Igor and I are going to record a podcast on that later today as well. That's going to be released as kind of a special edition of the Canadian Immigration Podcast. So go check that out. And a reminder once again that we have a ton of content out there for you guys. So not just what we're doing in these live Q&As, but please go check out the Canadian Immigration Podcast. We've especially anything business related. There's just a ton of topics on the whole foreign worker program, how it works. And those of you who are looking at job offers and trying to see, whether or not a job offer is genuine or how it works, these podcasts can educate you to know what to expect and how it really works, so you can identify a scam when it arises. Also, on our firm website, we have a ton of information in our blog that we definitely encourage you to read, as well as topics, all different kinds of topics, and information on different areas of Canadian immigration. So definitely check those out. And remember, subscribe to the YouTube channel, subscribe to get notifications wherever you're watching this. And thank you everyone for joining us. And we'll be back again next Wednesday, same time, 10 a.m. All right. Take care, everyone. See you later.